بدأ في يعني أصبح ساريا في الأول من يناير 2020، وهو أثر على البيئة التنظيمية في الصين التي تخضع لها البيئة الاستثمارية، بيئة الاستثمارات الأجنبية في الصين، وحل محل مجموعة 3 من القوانين السابقة في الصين في الشركات المملوكة بالكامل لشركات أجنبية والشراكة شركات المحاصة، وهو يعني يؤشر لانتقال جديد إلى هذه الحالة والبيئة الجديدة. في هذه الملاحظات التي سوف أطرحها سوف أشير بعجالة كما ذكرت، فهو أصبح إطار جديد وتخفيض القائمة السلبية التي كانت سائدة سابقا، والتي تحد وتحظر على بعض المستثمرين الدخول إلى بعض القطاعات. في هذه البداية سوف أعطيكم بعض يعني ملاحظات. القانون الجديد يتكون من 42
on foreign investment promotion, protection, and administration. Also imposes legal liabilities on both foreign investors and
Yes, Professor Shai, we can't hear you. تسمعونها؟ اي بعد احنا بالمنصة باخر الدنيا الكاميرا مضبوطة. Yes, Professor Shai.
أريش ترى ما في صوت.
صوت وقف صوت.
عندك.
I think you have a problem in the service, maybe, because it's open for you.
الحين نسمعش أريج.
أنا تسمعوني؟ إيه معناتها المشكلة عندها هي. Okay. We will move to Sarah. We will move to Mr. Queen. It's okay, Mr. Queen, until she fixes her service. انتقلي حق Mr. Queen, Sarah. هي عندها مشكلة بالسيرفيس.
Queen, are you here? Are you there? You're listening to us? Yeah. Okay.
Me? Okay. I'm Chen. Pronounce Vincent Chen.
Okay, you can start, please.
Okay. Hi, everyone. My name is Vincent Chen with Stanton's Beijing office. I was glad to be invited by Rich Kamara to give speech at the webinar Doing Business in China. And my topic is the legal system of foreign investment in China, which will include the legal system of foreign investment enterprise, FIE, and a new foreign investment law, FIL, and a special administrative measures negative list. A very brief introduction to this legal regime. FIE is called Foreign Investment Enterprise. Generally, the legal resource of FIE legal system consists of FIE laws and related regulations, and also administrative rules by its related departments under the State Council, and an industrial catalog, guideline catalog, M&A regulation, partnership enterprise law and company law, and a special regulation on oil and gas cooperation with foreign investors. And traditionally, if foreign investor enterprise can be either Sino foreign equity joint venture, so it's called an EJV, and or wholly foreign owned enterprise, WFE, or Sino foreign cooperative enterprise, called CJV. Here are the approval rules for FIEs. For EJV and CJV, application should be submitted by Chinese partner for approval. For WFE, application should be submitted by local government, and authority for approval is like this. Project should be approved by NDRC, used to be SPC, State Planning Commission. Now it's National Development Reform Commission. And article of association and joint venture contract should be approved by MOFCOM, MOFTEC, and now it's MOFCOM. MOFTEC is the Ministry of Foreign Trade and Economy. MOFCOM is Ministry of MOFCOM. And finally, after project and article of association and joint venture contract approval was obtained, then the investor should go to register the FIE with the State Administration of Industry and Commerce, or its lower branches above county level or regional level. According to FIE laws, FIE cannot be established without a project. That means you must have a project to be approved by NDRC, then you can establish the foreign investor enterprise. Traditional FIE was established through greenfield investment, and a natural person of Chinese citizens was excluded from being a partner to FIE. In 2006, when the provision on foreign funded mergers and acquisitions of domestic enterprise was jointly issued by 6 ministries, then such rules were changed. It was clarified that FIE can be established through M&A, including acquisition of assets, shares, or subscription of increment of capitals of a domestic company. As an outcome of M&A, Chinese individuals can become a legitimate partner of FIE, that means including CJV or EJV. During the early stage of opening up, FIE used to enjoy tax preferential treatment. Many FIEs, in fact, did not pay so much corporate income tax. And for oil and gas sector, business license was only granted to several state-owned enterprises. And accordingly, only these companies have exclusive rights of cooperation with foreign investors, either offshore or onshore. These rules were not changed until recently. That means last year, at the end of last year, the Ministry of Natural Resources issued a new provision on reform of mineral resource management policy, deciding to open oil and gas industry to all kinds of investors. But such rules did not draw public attention due to COVID-19 pandemic. On a special regime on management of oil and gas, there's no requirement of establishment of a FIE, only a petroleum contract or product share contract being approved by the state is a must. On the FIE legal system, it is important to know industrial guideline policy, which was adopted by the state to guide foreign investment since 1994. In 1994, 3 minutes jointly issued temporary provisions on foreign investment guidelines. Shortly after that, foreign investment guideline, the first foreign investment guideline was released. And in 2002, the State Council issued a regulation on foreign investment guidelines, restated that the industrial guideline policy should apply to foreign investors. The policy also stipulates that catalog of priority industries for foreign investment in Central and Western regions should also be basis for examining foreign investment approvals. So that's a very quick introduction to the FIE legal regime. Foreign investment law, I know Professor Shi will continue speaking on this topic, so I will go over just very quickly. Foreign investment law of the People's Republic of China was enacted last year and became effective on January 1st this year. It has 6 chapters, but only 42 articles. The most important parts are about the law was in the background is this law was enacted amid the situation of Sino-US trade conflicts, Chinese government adoption of supply-side structural reform, and a downturn of Chinese economy. At the aim of reaffirming state policy on opening up and encourage foreign investment. Specifically, it regulates that China adopts the legal system of pre-establishment natural treatment and a negative list for foreign investment list, and offering national treatment to foreign investments outside the negative list. Actually, these policy and rules or principles were put in place before this law was made. But this law endowed this with higher authority in the foreign investment laws. The foreign investment law stipulates that organization form and structure and operating rules of FIEs are subjected to the provisions of company law and partnership enterprise law and other applicable laws. That means formally enacted foreign investment laws will no longer have priority over application of a company law and enterprise law and company law and partnership enterprise law. Since the FIE law were repealed after the effect of foreign investment law, according to foreign investment law, all formally established FIEs have to be restructured to be in compliance with all regulations of company law and partnership enterprise law and other laws. The general principle is for non-legal person, CGV, it could be restructured to be in compliance with the partnership enterprise law. Otherwise, they have to be structured to be in compliance with company law, or including limited liability company or company limited by shares. There are 2 kinds of companies on the company law. There are remarkable cooperative governance regulations difference between a FIE or a company. For instance, on the FIE laws, all major issues should be decided by board of directors, and there's no shareholders general meeting, and it should be decided with unanimous consent from all directors present at the meeting, which is not practical in many circumstances. FIL, foreign investor law, also has regulations on other issues such as declaration of engagement concentrations and a state security review, which will come up during M&A and even greenfield investment. But these rules on these issues are almost the same as other jurisdictions around the world. The investment access policy was generally stipulated in foreign investment law by applying different policy of management, while specific measures are reflected and included in negative list. The Supreme Court has also issued an interpretation on application of foreign investment law, which gives great support in dealing with disputes regarding validity of a foreign investment contract, saying that for an investment contract formed in any field not included in the negative list for foreign investment access, where a party consent claims that the contract is void or invalid, citing that the contract has not been approved by or registered with the relevant administrative authorities, the People's Court shall not support the claim. That means all these kinds of contracts should be deemed to be valid. The Supreme Court has made it clear that all judgments should be made in favor of maintaining validity of contract of foreign investments. So this is a introduction of foreign investment law, and I expect to hear more from Professor Xu to speak on this. Maybe he will give us more in detail. The negative list. The definition of negative list is the State Council clearly lists the industries, fields, and business that are prohibited and restricted from investment and operation within the territory of China, and the governments at all levels take corresponding management measures according to law. All kinds of market entities can enter the industries, fields, and business not included in the list according to laws. There are two kinds of negative list: the pilot free trade zone negative list, and a negative list nationwide. The negative list was adopted in 2015 in an announcement of the General Office of the State Council, while the negative list nationwide was first embodied in the last version of Industrial Guideline Catalog for Foreign Investment in 2017 to replace the prohibited and restricted areas for foreign investment, which had been contained in former versions of Industrial Guidelines Catalog since 1994. The pilot negative list was created to take bolder reform measures of opening up in pilot free trade zones. In 2013, there was only one pilot free trade zone in Shanghai, but now we have 18 in the whole nation, country in total. For instance, film making, making of Chinese herbal medicine, performing arts, fishery of aquatic products are prohibited in negative list. In national negative list in 2020 version, but are allowed in 2020 version of pilot negative list. So there's difference. And generally, if such measures are proved to be practical and successful in pilot free trade zones, it might be adopted in an active list nationwide. The recent version of pilot negative list and an active list nationwide were jointly released by MOFCOM and NDRC concurrently on June this year at the aim of further opening up and high quality development amid the situation of containing COVID-19 pandemic and strong demand of economic recovery, while the Sino-US relation was deteriorating and is in tension. The new lists have continued to curtail the negative list for foreign investment. There are only 33 items on the national negative list and 30 items on the pilot negative list. Among the significant changes, China will scrap foreign shareholding limits in security companies, fund houses, futures companies, and life insurance firms. China will ease market access restrictions in manufacturing and agricultural sectors and scrap a ban on foreign investment into companies that smelt and process radioactive resources and produce nuclear fuel. Besides, opening up policies will continue to be implemented at free trade zones. Industrial guidelines on encouraged foreign investment was renewed in June last year. The main version of the new encouraged guideline includes encourage foreign investors' participation in high-end production, encourage foreign investors' participation of production-oriented service sector, and encourage participation of industrial transfer in Midwest region. This guideline is on the way of renewal, and soliciting for public opinion has ended at the last day of last month. In a circular issued by MOFCOM for stabilizing foreign investment in response to the pandemic, MOFCOM restated that the nation will adopt the doctrine of entry unless on the negative list in all sectors, and will take investment attractions efforts to stabilize foreign investment, emphasize the principles of no restrictions measures targeted at foreign investment access shall be implemented for sectors outside the negative list. I think this is my very quick introduction and very general introduction to the foreign investor related legal system. I hope we can discuss later. Thank you.
Thank you very much for this amazing presentation. Sarah? Rashidi.
Hello, everyone.
Hi, Sarah. How are you? Finally, we see your video. Sarah,
yes.
She's now. First, I will say I would like to say welcome in our webinar. And just I want to tell you also, she's now my president in the cross-border investment in the IPPA, and we hope that we all the best in the next this year, inshallah. Okay, so you can start your speech, please.
Yes, thank you. Good afternoon or good morning, everyone. Thank you, Arish, for this invitation, and I'm very happy to meet you all. Apologies if my video was not working from the very beginning. I don't know what happened. As Arish was saying, we were so lucky to meet each other at the Inter-Pacific Bar Association conference. And she was so kind to agree to be one of the vice chairs
snapshots. Where Sarah, I think she go. ذبحنا. Okay, we will start with Sarah. Sarah Rashidi. اسمعيني؟ خلينا نبتدي مع يا سارة. Hi Sarah, she come again. Yes, Sarah. رحنا ما ادري ايش صار. السيرفيس عندهم كلش. Sarah, do you hear us? Sarah, كلهم راحوا كنا كلهم اختفوا. Okay, we start with دكتورة سلوى. هلا دكتورة شلونك؟
هلا حياك الله صبحكم الله بالخير.
حييك. We have she was the first woman in the parliament in Kuwait, دكتورة سلوى الجسار. Welcome in our webinar. الساعة المباركة والله طلعتي لنا.
حبيبتي good morning to everyone. Welcome our partner in China to share with this event. I would like to express my feeling and thanks to my neighbor and my friend and the lawyer Ms. Arij Hamada to invite me. I was joining you since you give your speech in the beginning. I interested for this event because as you know, with coronavirus and our vision of our state in Kuwait, we would like to share so many chances to discuss this opportunity through communication business between the state of Kuwait and China. I wish you a good luck for everyone. I will be follow all the speeches, so maybe we can share some ideas and questions. Good luck to you, Ms. Arij. وحياكم الله ما شاء الله منورين حبايبنا من الكويت ما شاء الله. I'm very proud. يمكن شوية تحيز وايد للنساء لأن وايد إحنا يعني we need to support each other. Thank you so much my dear. Thank you Ms. Arij حبيبتي.
Thank you.
منورين.
أريج تسمعيني أريج؟
أنا ما أدري وين راحوا والباقي. مو موجودين. ما هي قاعد تتكلم كلمة.
لا بس أريج ترى شو اسمها مو فاتحة الميكروفون. هو مشكلته ما قاعد يفتحوا الميكروفونات.
ما ادري ايش فيه قاعد يعلق معنا. وينهم ماكو ولا احد. Elisa, can you start please? Yes, Elisa. Yes. Start because I don't know the others where they disappear. She was
No problem, I'm ready.
Hello?
Yes. So we will start with you until they okay, yeah, Mr. Wang. Hi, Mr. Wang. Okay, we will start with you, Elisa, until they.
Shall I start?
أريد معيني؟
مين اللي قاعد يتكلم؟
ألو؟
Okay, Mr. Wang, you start, please.
Okay. Thank you, Arij Hamada, and thank you for everyone attending to this webinar. Okay, today I'm going to talk about foreign investment in China, what's new in 2020. My name is Wayne Wang. I'm a partner of China's Zhongren law firm, and I'm a lawyer admitted in mainland China, Hong Kong, and Australia.
Thank you. You're welcome. You can start.
Thank you, everyone. Yeah, firstly, I think Vincent Qian and Professor Shi have already talked about many of the that's okay, but I will perhaps talk about it from a different perspective, from the perspective of a Chinese lawyer working for foreign investors in China. So the focus is on the foreign investment law. My friends, Professor Shi and Vincent, have both mentioned about it. This is a new law coming effective from 1st of January of 2020. It has overhauled the legal system of China relating to foreign investment. So how does it affect the foreign investors from the practical perspective? I think traditionally China is a civil law jurisdiction, but according to my experience, in recent years, the business law of China is becoming more and more similar to the common law jurisdictions. As I mentioned, I'm qualified in both mainland China and Hong Kong, and I think now many of the provisions of China's commercial law is similar to the law of Hong Kong or the UK. Many rules have been relaxed. Just to summarize the foreign investment law, I think it is more open to foreign investors, more simple and there will be less administrative interference. In summary, it's now, I think it's closer to international standards, the business law of China. So it's very friendly to foreign investors. So that's my personal view. For example, why do I say that? You need to have a minimum registered capital or share capital. I understand that there is such a requirement in many other civil law jurisdictions. In other jurisdictions in Europe or Japan and Korea, you need to pay up the minimum share capital within a certain time if you set up a company. But now, according to the new law of China, there's no such requirement. So there's no minimum capital requirement, and you can pay up the share capital within 30 years, according to my experience. So for example, you estimate that your company will require a share capital of, for example, $1 million US. And as the shareholder, you can pay up the capital within 30 years. And just earlier this month in Shenzhen city of China, the local government has enacted a new law which says that the shareholders of company can have different rights. So before it was very strict in China. The shareholders holding the shares should have the same rights as long as they have paid up their capital. But now under the new law in Shenzhen, as a shareholder, you can have different rights. For example, some shareholders may only invest money and they don't want voting rights. Before that was not permitted in China, but now it's all okay in Shenzhen. And if this reform is smooth, it may be copied in other cities of China in the future. Another example is about share transfer. If you transfer the shares of a company in Europe, you need to do it before a public notary. I understand that there are many procedures involved. But in China now, there's no such thing, no need for public notarization. The share transfer will become effective as long as it is registered in the internal book of the company. You still need to lodge filings to the company's registration authority, but that doesn't affect the effectiveness. It only has the effect against third parties. So in this respect, it is similar to the law of Hong Kong. So about the negative list, I think Vincent has also mentioned about this. So what does that mean? To put it simple, I think so the Chinese government will enact a list from time to time. If your investment is not on the list, then that means it is permitted, to put it in a simple way. And the list has been reduced year on year. So every year the restrictions become a key feature of the foreign investment law. Under this law, so foreign investors should be treated equally, and the treatment to them shall be no less favorable than that afforded to Chinese domestic investors. And also, foreign investors can supply goods and service to government bodies, and they shall be treated equally. About the negative list, so in the last year, it has been reduced by 17.5%. So before there were 40 industries on that list, which have some restrictions on foreign investment. But now, according to the new list this year, it has been reduced to 33. I know that Kuwait has many oil companies. So in relation to oil production, before oil and natural gas production was on the negative list. It can only be done in China through a joint venture with a Chinese company. But now, according to the new negative list, this restriction has been removed. So it means that you don't have to set up a joint venture with a Chinese party. And according to the new law, the main requirement is that the foreign investor shall have a net asset of not less than RMB 300 million. That's about roughly 40 million USD net asset. Okay, as I mentioned, under the foreign investment law, now it's more simple. Why is it simple? Because you can set up a company quicker and cheaper now in China. Before, I have seen one foreign company who spent more than a year and more than $200,000 just to set up a private company in China. But that was a few years ago. Under the foreign investment law and the other implementation rules, now there's a so-called one-stop shop for all company incorporation filings. Before, you need to lodge filings with various authorities offline, but now you can lodge all documents through one online registration system. And the time frame for company formation for foreign investor is about, according to my experience, about 2 to 4 weeks. It can be done in most cities, although it's still different from city to city. I mentioned that the Chinese government now has a website for formation of new companies in China. So you just need to lodge the documents online. But that website is in Chinese only. I have launched a new website in English for foreign investors. If you're interested, you can contact me later and I can send you the website, because today I cannot show the PPT, but my website has some so-called AI functions. So if you fill in all required information, it can automatically produce all application documents for you within seconds. And there is a chatbot on my website that can answer your questions on a 7 days and 24 hours basis. And the chatbot can explain the PRC legal jargons in plain English language for foreign investors. And the website can provide free online services. If you have more complicated questions, you can always contact our legal team of our lawyer, of our law firm offline. Under the new foreign investment also, there are also other key features such as the express prohibition of forced technology transfer, and there's also enhanced protection of trade secrets and increasing penalties for IP infringement. And foreign investors are allowed to freely transfer royalties in and out of China. Okay, that's briefly about the law. I can also introduce you about the new opportunities or what's hot in foreign investment in China in this year. So what's hot after COVID-19? We know that in the second quarter of this year, the GDP of China had a positive growth of about 3.2%. The FDI number in China has fallen, but not that much. It only fell about 10% year on year in the first quarter of this year. According to Asian Development Bank, the GDP of China will still grow this year at about 2.3%, but in the next year, it is forecasted that will go by about 7.3%. And the Chinese government has announced an infrastructure development plan that was about $7 trillion. We call it new infrastructure construction, which is very hot and ongoing in China now. And the key industries include medical and pharmaceutical, AI, big data, and new energy. New energy. I would also like to mention about the two government initiatives about the so-called Greater Bay Area in Guangdong, Hong Kong.
بصل ثوم وليمون عصري وهذا كله قصي صغير صغير خضرة ليمون عصير.
Okay. So in 2018, the Chinese government released the plan for the development of the so-called Greater Bay Area. So the aim is to develop the Hong Kong, Macau, and Guangdong region into an international technology, finance, and business center, comparable to that of Tokyo Bay in Japan and California Bay in the US. The other one is the so-called Hainan Free Trade Port. So the Greater Bay Area, it has a total area of 56,000 kilometers and a population of 71 million and a GDP of US dollars 1.66 trillion in 2019. There are many preferential policies for foreign investors in the Greater Bay Area. For example, the cross-border financing between mainland China and Hong Kong is supported by the government. We have been involved in many of the cross-border financing transactions between mainland China and Hong Kong since the Greater Bay Area initiative has been released. And there are also many measures to further open up the market in Guangdong to foreign investors. For example, in banking, securities, insurance, and also in new energy car. Before, you need to, there was restrictions on foreign shareholding if you invest in new energy car manufacturing, but now such restriction has been removed. And the second one I want to talk about is about Hainan Free Trade Port. So Hainan is the second largest island of China. It has a total area of 35,000 kilometers and a population about 9.4 million. Why is it important? Because it is bigger. According to government's plan, Hainan will be a free port, similar to Hong Kong. But Hong Kong has only about 1,000 kilometers, and Hainan has an area, as I mentioned, 35,000 kilometers. So foreign investment in Hainan has been very hot in the last couple of years, especially in industries like wholesale and retail and technology service, leasing and real estate manufacturing. Okay, why is it different? Firstly, I mentioned that the entire Hainan island with an area of 35,000 square kilometers is a free port now. It is about 35 times bigger than Hong Kong. And there's zero tariff for import of products to Hainan. And the personal income tax is 15% in Hainan. In comparison, the personal income tax is 17% in Hong Kong, 22% in Singapore, and up to 45% in mainland China. The corporate income tax in Hainan is now 15% for many industries, not for all, but for many industries. And we know that in mainland China, it's 25%. Okay, I have prepared a PPT about our law firm, but since you cannot see the PPT, perhaps I can just briefly talk about it to you. So our firm, Zhonglun Law Firm, is the top-tier PRC law firm providing full services in China, with more than 12 offices in the major commercial centers of China. We have over 340 partners and over 2,200 lawyers. Yeah. And according to Chambers Asia Pacific 2020, we are the PRC law firm with the most practice areas recommended. And about myself, as I mentioned, I'm a partner of Zhonglun. I focus on cross-border M&A, banking, finance, and China outbound investment. Oh, okay. So the last page of my slide is my LinkedIn QR code, but since you cannot see it, perhaps you can find my contact details on the website of Zhonglun, or you can contact the host about my contacts. Thank you. Thank you, everyone.
Thank you very much. Sarah Rashidi, حق البروفيسور شاي again please لأن مساء انقطع معاها السيرفيس. Yeah, we will start again with you, Professor Shai. We are sorry for what happened. Just remove and unmute.
Yeah, unmute your, okay.
Okay, I'm not sure whether how much you have listened to my speech. Shall I begin from the very beginning or?
Better to begin. It's better to begin, please.
Okay. So I will beginning from the first part of my speech. As I said in the first part, I would like to give you a snapshot of the new framework. As several the panelists already mentioned, you know, many aspects of the foreign investment law and related instruments. I will be, I think I will be very brief. Okay, again, the law is composed of 42 articles in 6 chapters, mainly focusing on foreign investment promotion, protection, and administration, and also imposes legal liabilities on both foreign investors and Chinese regulators in the case of violation. The law provides generally, you know, for great promotion and protection of foreign investment, as well as enhanced regulatory transparency. In addition to the law and its implementation regulations, the Supreme Court, People's Court also issued a short judicial interpretation regarding investment contracts, which also came into effect on January 1st this year. I noted, you know, mentioned this judicial interpretation already. Furthermore, the framework for foreign investment in China also includes the special administrative measures for foreign investment, also known as a negative list, and the catalog of encouraged industries for foreign investment. You can call it as encouraged industries catalog for short. So the latest versions of these 2 instruments took effect on January 30th last year, 2019. The most significant highlights of the foreign investment and its related instruments can be summarized from my observation, you know, as the following 7 points. The first one is about the broad scope of foreign investment. Foreign investment is defined very broadly in the new law, covering both direct and indirect foreign investment. So in terms of for investment forms, it includes greenfield investment via like set up a new foreign investment enterprise, and also brownfield investment through merger and acquisition. And also, you know, so-called new investment projects, which is also included in the definition, which can, you know, subject to a broad interpretation as well. The second point is a pre-establishment national treatment. This is also already mentioned by Vincent. I think this is one of the most significant changes in the new law. This has transformed from post-entry or post-establishment national treatment into pre-entry or pre-established national treatment. What does it mean? And the new law, China implements actually, the pre-established national treatment coupled with negative list system. This means that foreign investors are treated no less favorably than Chinese investors at their entrance stage, as long as the invested industry is not on the negative list. According to the Supreme Court judicial interpretation on the foreign investment law, a Chinese court should not nullify a contract regarding a sector not on the negative list because of lack of approval or registration, but should nullify a contract regarding a sector on the negative list. That being said, investment contracts regarding sectors on the negative list can still become effective if the parties take corrective measures before the court adjudicates the case. If a contract involves a sector on the negative list, it can still be effective if such restrictions are removed before a court issues a subjection. This means, the negative list and the negative list I just mentioned, it's subject to constant revision in China. So you need to pay attention to its latest version. It is supposedly it will be shorter. The third point is related to pre-entry or pre-establishment national treatment, which is primacy of national security. The foreign investment law requires a national security review of any foreign investment that has or may have an impact on China's national security. This is very important because under the pre-establishment national treatment, coupled with the negative list system, you can understand that China now is not approving foreign investment as previously did on a case-by-case basis. So under the new regime, national security review actually acts as a safe valve. But regrettably, the new law right now in its current version lacks details in this regard. The fourth point I'd like to mention is so-called unified corporate governance, because the new law replaced the three previous foreign investment enterprises law, which involves repealing, the separate corporate law framework that applies only to foreign investment enterprises before. So under the new regime, a business entity's corporate governance depends on its form, not on whether it's domestic, Chinese invested or foreign invested. So as domestically invested companies, foreign investment enterprises are only subject to China's company law, partnership law, and other laws that regulate business organization. These should offer investors with more flexibility in structuring and operating foreign investment enterprises in China. Note that the law also provides a 5-year grace period for foreign enterprises whose corporate governance needs to be adapted. The fifth point is about foreign investor protection. I will be very brief on here. The law generally provides various measures for the encouragement and protection of foreign investment, including a formal entitlement of foreign investors to national treatment. I hope this can answer, one of the Mohammad's one of his 3 questions. As well as an assurance that foreign investors can participate in the government procurement market, allowing a foreign investor to remit lawful income out of China, and a prohibition in principle, or you can say a restriction on expropriation or nationalization. The 6th point is about IP protection. The law contains a number of provisions to address concerns among foreign investors about IP protection in China, including a prohibition against the use of administrative measures to force technology transfer, a requirement that government authorities protect foreign investors' trade secrets, and enhanced remedies for IP violation or infringement. The last point I would like to mention is the so-called integrated foreign investment reporting system. The foreign investment law requires establishment a integrated foreign investment reporting system for the submission of investor information to the Ministry of Commerce, MOFCOM, through the enterprise registration and the enterprise credit information publicity systems administered by the State Administration for Market Regulation. To this end, the MOFCOM and State Administration for Market Regulation jointly issued new regulations and laid the groundwork for the reporting system, which also took effect on January 1st, 2020. So in my second part of the speech, I will briefly make the positive assessment of the new law and as well as negative concerns caused by this new law. First, a unified governing law of foreign or regulating law for foreign investment could help reduce the previous confusion for foreign investors, easing the process of investing and doing business in China. Second, the foreign investment law offers a range of benefits for foreign investors in China, such as a shift to a more permissive corporate governance rules, greater flexibility in funding foreign investment enterprises, leveling the playing field, as well as enhanced protection of intellectual property rights. Third, the new law seeks to address common concerns from, for a long time from foreign businesses and governments, such as by explicitly prohibiting forced technology transfers, promising better intellectual property rights protection, and ensuring equal
shortcut presentation, please, because we don't have much time. There is another presenters.
Yeah, I know. Can you? It will be over very soon. For foreign firms in government procurement, however, the other side of the coin is remaining concerns whether the legislation will truly benefit foreign investors looking to business in China. This is largely because the new law and implementation regulations, even including SPC interpretation and other related instruments, are still way too general in nature. So it leaves many gaps to be filled. The lack of that may bring business operating in China. There are many issues waiting for further clarification, including the so-called variable interest entity or VIE structure issues, national security review, and etc. So basically, the concerns over the vague wording and lingering uncertainties need to be addressed in order to provide some transparency in regulating foreign investment in China. My last part is about, very brief adaptation of foreign investors to the new system. The legislation and the related instruments established a new legal framework for the management and the promotion of foreign investment in China. So foreign investors and their subsidiaries in China need to familiarize themselves with this new regime in order to comply with and benefit from it. There is no one-size-fits-all prescription here. Rather, I think different foreign investors should have different to-do lists depending on their individual situation. In general, investors should seriously assess the new law's impact as it develops further, keeping a close eye on the related legislation, regulations, local administrative approvals, and even, some window guidance of relevant bureaus in China. Just 5 days ago, there is a new piece of development was issued, by MOFCOM. MOFCOM promulgated the working procedure for lodging complaints by foreign investment enterprises, which is the key step, I think, to safeguard the lawful rights and interests of foreign investors.
Thank you so much for your presentation. Now we're going to lawyer Aloisa Hu, foreign-related legal service, legal framework before and after FIL, negative list system, technology transfer, limitation, investment promotion. Ms. Hu, you can start your presentation. Each presentation will take 10 minutes, please. Thank you.
First, I would like to say thank you for Professor Chai. Thank you very much for your amazing presentation. Thank you. And we will start with Lisa, please.
Yes. Hello, everyone. My name is Aloisa Hu. I'm from Wangjing & GH Law Firm from Guangzhou, south of China. Today, first of all, I would like to express my gratitude for being invited to this webinar. My daily work involves a lot of foreign related legal service. So basically foreign investment is a major part of my job. So I'm also very glad and honored to be able to be here and share my point of view with all of you about the foreign investment in China. And I'm sure that by far all of us have heard and learned a lot from the previous speakers about the legal framework of foreign investment in China, the negative list, etc. So in my section, I will mainly focus on the favorable measures introduced by the foreign investment law and the implementation rules on national level, as well as some preferential policies promoted by local governments. For example, Guangdong province, the province where I am in. We all know that since the entrance into effect of the foreign investment law, it has brought a considerable amount of favorable measures for foreign investment. And I would like to introduce 5 major favorable measures in this section. First of all is the equal treatment. The foreign investment law clearly stipulates that all government and its departments shall equally treat companies with foreign investments and domestic companies in terms of government funding, arrangement, land supply, tax and fee reduction and exemption, qualification and license granting, establishment of standards, project applications, human resources policies, and government procurement tender. So it's the first time that on legislative level, foreign invested companies are placed in the same playground together with domestic companies on some very important aspects. The second favorable measure I would like to introduce is the government obligation to honor the investment agreement. Sometimes when the foreign investors come to China and if the investment project is big enough, the local government would want to sign an investment agreement with the foreign investors and offer some local preferential policies in exchange to secure the investment amount and the yearly tax income. But of course, there is always this fear from the foreign investors about whether the local government can hold on to the other end of the contract. So the regulation for implementing the foreign investment law sets up some obligation for the governments to honor the compromises and the undertakings they made in the agreement signed with the foreign investments in accordance with the law, and the local governments shall not breach contract using excuses such as adjustment of administrative district, change of personnel, or change of governmental institution. And confiscation of the foreign investment is not allowed unless it's due to public interest. But even under these circumstances, a fair compensation shall be provided to the foreign investors. The third favorable measure I would like to talk about is the simplification of the registration and reporting procedure. I think just now Lawyer Wang has briefly mentioned about it. Right now, there is no additional registration in the MOFCOM system at the moment of company establishment or change of registry. So foreign invested companies are not required anymore to achieve the registration receipt issued by the MOFCOM in order to complete the whole registration procedure. On the other hand, regarding the information reporting scheme, foreign invested companies are not required to repeatedly report information that input in the system of enterprise registration. So different authorities, if they want to have access to this information, they shall access to the system and acquire the information by themselves. So this, in a way, has lifted the burden of information reporting from the foreign invested companies, and which of course is a good news. The fourth point I would like to mention is the relaxation on domestic equity investment using registered capital. Before October 25th, 2019, only foreign invested companies whose business operation is investment or has investment in its business scope can use the registered capital in domestic equity investment. But since this new measure taken by the State Administration of Foreign Exchange since the end of last year, now all foreign invested companies can use the registered capital in domestic equity investment. And this for sure provides convenience and better usage of the registered capital for foreign invested companies whose business scope is not investment or does not include investment in the business scope. Of course, these are the other major favorable measures on the national level, and the laws and regulations also open the possibility for local authorities to make their own preferential policies in order to attract foreign investment. And here I would like to use example of Guangdong province which is 150 million, and with the GDP of 10.7 trillion RMB in 2019. As an example, to just give you guys an idea about how the local preferential policies can be. The first and the most common preferential policy that the local government would give is the economic reward. It means that the local government will give some economic price equal to certain percentage of the total investment, or equal to the yearly tax contribution if the investment project or if the yearly tax contribution reaches certain threshold amount. For example, in Guangdong province, the government offered reward equal to 2% of the foreign investment amount if the new foreign investment project reaches $50 million US. The second most common preferential policy is the land supply. Most manufacturing companies at the moment of choosing the destination of the investment will for sure consider a land slot with easy access from logistic point of view, so they can easily bring in the raw materials and transport out the goods, right? So a good land supply for them is super important in this investment project. So in Guangdong province, for construction projects of the headquarters of manufacturing enterprises with investment of more than 1,000 million RMB, the municipal and the provincial government will make sure to arrange the land supply. So for sure, this is a good news for the manufacturing companies who is looking for opportunities for investment in China, especially in south of China, which is also near to Hong Kong, Macau, and with easy access to the sea for the sea shipment. The third local preferential policy that I would like to introduce is the funding. For example, in Guangdong, the Guangdong province has an industry development fund, which is supporting the world top 500 enterprises, the worldwide sector leading enterprises in the province with equity investment. And in addition, the province is also promoting the pledge of intellectual property right as a finance method. Last but not least is the tax incentive. The local government is usually very often willing to offer some tax incentive if the foreign invested company has made certain economic contribution to the local economy. But of course, these four local preferential policies are just the most commonly seen policies, and each region, province, city will have the authority to offer different kind of policies depending on their own need and depending on their own situation. So it's recommended to all the foreign investors that before choosing the destination assistance to talk and to have a better understanding of the local preferential policies so that you can have better leverage in the negotiation period with the local government and local investment authorities. And this is my part of the presentation. Thank you very much for listening. And if you have any questions, please don't hesitate to raise your hand. Thank you.
Thank you, Elisa, for your lovely and amazing presentation. Thank you very much. Okay.
Appreciate your presentation, Mr. Rauf. Now the lawyer Sarah Marquita, the co-chair of a cross-border investment IPVA. You may present your presentation, Ms. Sarah.
Sarah Marquita, Sarah. You can start. هي طرشت لي ايميل ما ادري موجودة بس مي كاتبة. خلاص عيال أدير وينها موجودة؟ تبلشين مع غدير؟
اوكي، استاذة غدير الجمعة، رئيسة جمعية ريادة الأعمال. تفضلي استاذة غدير برزنتيشن. حياك الله.
السلام عليكم، يعطيكم العافية. بس ثواني إذنكم. السلام عليكم، يعطيكم العافية على الدعوة الجميلة، وما شاء الله هذا المؤتمر جدا رائع، أنا حبيته. موضوع جديد، فكرة جديدة، أول مرة أروح الكويت، وكان هذا دليل على إن حرصك واهتمامك بأهمية الشراكة بين الصين والفتح الخليجي أيضا بالإضافة للشرق الأوسط. وإحنا نتشرف كجمعية ريادة الأعمال التنموية أن نشارك في هذا المؤتمر المتميز من نخبة رائعة من شخصيات مميزة. اليوم أنا راح أتكلم مع موضوعي راح يتكلم أثر الحاضنات الأعمال على النمو الاستثماري والتوسع لرجال الأعمال. تلعب حاضنات الأعمال بجميع أنواعها دور مهم في دعم وتطوير المشاريع الريادية، نمو الاقتصاد الوطني. تعتبر أداة لإعاش وتنمية الاقتصاد ثابت الاقتصادي، وتكون ثروات ونشر والتي تساهم في أخطار الاستثمار للمنظمات وخلق فرص. ازداد الاهتمام بالحاضنات الأعمال على مستوى العالمي وحتى العربي، وكونها أثبتت التجربة خلال أكثر من عقدين من الزمن، إذ تمثل أحد المرتكزات الأساسية ونجاح المشاريع الرئيسية من خلال التغييرات بدايتها، إذ يمكن المنظمة الجديدة والصغيرة بداية أول خلال منها، وكذلك المنظمات الكبيرة التي تمر مرحلة وترغب بإعادة نشاطها من خلال المبتكر المبادر وتوجيهات جديد وخدمات يترتب عليه استحداث الصناعة يمكن أن تفي بحاجات السوق منتجات مع نلاحظ زايد نسبة نجاح المشروعات المحتضنة مقارنة بالمشروعات المحتضنة بسبب توفير لهم بيئة
حبيبتي قاعدة الصوت.
المشروع الريادي وبتطبيق برنامج تنموي يساعد في تنويع النشاط وتكوين الثروات المنافسة عن طريق الخدمات التي تتبع حاضنات خدمات استراتيجية
غدير قاعد يقطع الصوت
والتمويلية خدمات إجرائية لبداية إطلاق التمويل والموارد البشرية والشبكات، خدمات تحتية توفير مناسب من مستلزمات الإنتاج وبعض اجتماعات، وتساهم حاضنات بأنواع مختلفة على النمو والاستمرار والتوسع للأعمال لما لها دور في تنمية الصناعية والتقنية والبشرية وفرص لذا أن جمعية ريادة الأعمال التنموية تركز على مجموعة من الأهداف الخاصة لحاضنات وهي تحديات حاضنات الأعمال ودورها في دعم مشاريع منظمات الأعمال المختلفة. يتم ذلك من خلال برامج تشجيع وتطوير وعقد الندوات والمحاضرات دور الحاضنات في نجاح المشاريع والتعاون بين حقوق القطاعات حث مستثمرين الأموال الاستثمار في الحاضنات الأعمال ومؤسسات المجتمع المدني، خاصة وأن السوق أمامها مفتوح ويتوقع عن فتح باب التعاون بين المؤسسات المجتمع المدني العالمية فعليا بدعم مشاريع وحاضنات الأعمال. 4 عمل مسابقات بالتعاون بين الحاضنات المالية والعلم لتجميع روح الإبداع والابتكار المجتمع. وضع خطة استراتيجية الأعمال التي الأعمال من أجل تشجيع الصناعات الحاضنات القطاع الصناعي وخلال دعم غرفة التجارة الصناعية ومنظمات المجتمع المحلي. تنسيق العمل بين حاضنات الأعمال والتكنولوجيا حيث تكون العملية والتنافس بفتح التكامل والحوار فيما بينهما. احنا ندري أهمية الشراكة خاصة في السوق الصيني. السوق الصيني تميزهم في التكنولوجيا والإبداع ما شاء الله عليهم. أيضا في الفاقة وخاصة بعد أزمة كورونا لاحظنا تطورات التكنولوجيا وأن أزمة كورونا ما أثرت فيها. لذا فإن جمعية مال التنمية معهم كشريك وتعمل معرض تنموي للصناعات التطويرية التكنولوجية ذات اقتصاد وذلك الاقتصاد والخليج، وكذلك التبادل الخليجي والتبادل بين الدول. ويعطيكم العافية جزيلا امتنان رائعة متميزة وتشرف بالانضمام معاكم. ألف شكر أستاذ عبير.
للأسف ما سمعنا ولا شيء أستاذ عبير.
وايد مقطع، قاعدين نقول لك مقطع بس ما تسمعينا. زين نبتدي مع سارة المحامية الإيطالية. سارة هي موجودة فتقول هي تسمعنا بس ما أدري ليش إحنا عندنا معاها مشكلة من عندها الظاهر. سارة وينها؟ هي أصلا اختفت. أوكي
بس سكر المايك، سكروا المايك على الكل.
سكرنا. اوكي الحين انا عندي بس باقي بس كلمه المحاميه الايطاليه ساره، ما ادري شو نسوي. موجوده دازت لي الحين مسج.
عمو الدماستر كذا بورتي.
سكروا المايكات. Close the mic for everybody.
قاعد يدخلون. اوكي.
Just the speaker. Open the mic.
हेलो और भाई कैसे है? बढ़िया.
يلا اوكي.
हेलो अस्सलाम वालेकुम भाईजान.
हेलो जय श्री राम.
जय श्री राम भाई. जय श्री राम.
I don't like niggas at all. Niggas always playing basketball.
اوكي سمعنا انا مش نسوي له ريموف. يلا ساره تبتدين مع بدون سميت.
اوكي استاذه بدور السميط، انت رئيسه جمعيه رائدات الاعمال عدل؟
رئيسه شبكه سيدات الاعمال والمهنيات.
حياك الله حبيبتي.
الله يحييك. تفضل. اليوم راح نتكلم عن توسع الاعمال لاصحاب المشاريع الصغيره والانطلاق الى السوق العالمي. اتشرف بلقائكم في هذه المنصه مع الناشطه المتميزه المحاميه أريج حماده، واشكرها على الترشيح اني اكون بينكم اليوم. نتكلم اليوم عن المشاريع الصغيرة وفرصتها للوصول للأسواق العالمية، ولا شك في أن المشاريع الصغيرة تعاني كثيرا للثبات في السوق وزيادة حصصهم السوقية مع وجود أزمة كورونا.
हेलो जय श्री राम.
التي خلقت الكثير من التعثرات بالمقابل الكثير
جاي شري رام.
حيث أدت الأزمة إلى حركة سريعة لبعض المشاريع التي سارعت في مواكبة التكنولوجيا وتوفير حاجة السوق، بعكس بعض المشاريع التي لا تؤيد التغيير وتصر على العمل بشكل نمطي تقليدي لا يواكب التطور والظروف. ومما نراه لانطلاق المشاريع المحلية إلى العالمية توفر عدة عوامل، منها الجودة، حيث يجب أن تتمتع المنتجات أو الخدمات الخاصة بالمشاريع الصغيرة بجودة عالية لمواكبة السوق العالمي، وهي متوفرة لدى بعض المشاريع الصغيرة. 2. معرفة حاجات الأسواق العالمية من المنتجات أو الخدمات المراد تصديرها إلى تلك الدول. 3. تسهيل المعاملات والرسوم والإجراءات اللوجستية كالشحن والتخزين. 3. فتح سبل التعاون بين الدول وتسهيل العقود والاستثمار والوكالات وحقوق الامتياز. والأخيرة توفير منصات عالمية لعرض حقوق الامتياز لمن يرغب بالاستيراد أو التصدير. جميع هذه العوامل تساعد على انطلاق المشاريع الصغيرة إلى العالمية، ومما لا شك فيه أن دولة كالصين حققت الكثير من التعاونات مع الكثير من المشاريع الصغيرة لتوفير المنتجات التي يحتاجها العميل من المشاريع الصغيرة، والتي تصنعها المصانع الصينية طبقاً للمواصفات الخليجية المطلوبة بجودة عالية. وأيضاً تسعى شبكة سيدات الأعمال والمهنيات إلى دفع العضوات للمشاركة والوصول إلى العالمية ومساعدتهم عن طريق الجودة العالية وتعريفهم بشروط حق الامتياز لتصدير منتجاتهم للخارج. وهذا دورنا وخاصة للمرأة بدفع العجلة الاقتصادية وإعطائهن الفرص الصحيحة للوصول إلى الاستقلالية المالية. حرصنا على ذلك بتوفير الدورات وورش العمل والمحاضرات التي تساعدهن على ذلك، وتتم دعوة عضواتنا للمشاركة في المعارض حول العالم، كما حصل في السابق لزيارة معارض في دبي وباكستان وزيارات تدريبية كالولايات المتحدة وهولندا بدعوة من عدة جهات. إن وصول المنتج المحلي وتوسع المشروع الصغير إلى أكثر من دولة يعد إنجازاً للمبادرين بدأوا من الصفر بابتكار وتطوير خدماتهم ومنتجاتهم. لذلك اليوم مشاركتنا هي باب نفتحه لكم لتعريفكم على إنجازات المشاريع الصغيرة، وكذلك التعرف على إنجازاتكم بشكل أكبر. من التوصيات التي نود أن تكون ضمن جدول اليوم هو التعاون المشترك بين الدول بصورة لتبادل حقوق الامتياز أو التصنيع أو الاستثمار، أن تكون هناك منصة تجمع أصحاب المشاريع الصغيرة من البلدين، ترجمة المواقع الهامة إلى العربية أو الإنجليزية وخاصة المواقع الصينية. هذا ما نراه من أهم سبل التعاون لتحقيق الأفضل. وبعد استماعي للبعض اليوم ووجود القوانين الجديدة في الصين، أعتقد أن القوانين الجديدة تساعد على الاستثمار هناك في فتح باب الاستحواذ والشراكة والاندماج، وهذه من أفضل الأشياء التي تساعد المشروعات الصغيرة على التقدم خطوة والتوجه إلى الصين لعمل هذه الشراكات والاندماجات. مشكورين، يعطيكم العافية.
يعطيك العافية بدور وغدير، يعطيكم ألف عافية. سارة تكملين؟
اوكي، الحين راح يكون برزنتيشن مع الأستاذ المحامي خالد بشير. حياك الله أستاذ خالد.
خير، يعطيكم العافية. أهلا وسهلا بالسادة المشاركين، وأهلا وسهلا بالحضور، والشكر للسيدة الأستاذة المحامية أريج حمادة على هالاستضافة. أسأل الله لنا ولكم التوفيق. يسرني أن أعرض عليكم موضوع بغاية الأهمية يحتاج المستهلك والمستثمر، وهو الاتفاقيات الدولية التجارية والتي وقعت عليها الكويت، وهي اتفاقيات خاصة بحماية الاستثمارات المتبادلة BAT. ومجموع هذه الاتفاقيات 90 اتفاقية متنوعة بين الدول، ومنها أكثر من اتفاقية مع الصين. وقبل أن أتحدث عن هذه الاتفاقيات أو أهم بنود بعض الاتفاقيات، سأتحدث عن اتفاقية تيسير التجارة التي دخلت حيز التنفيذ في 2018 وأصبحت إلزامية ومهمة، وتعود بالفائدة على المستهلك والتاجر، وهي تشمل أهم نقطة في جميع الاتفاقيات لأنها تلزم بتخفيض تكاليف الاستيراد وفترة نفاذ السلع وبقائها في الترانزيت، كما أنها لا تتعارض مع الاتفاقيات الأخرى التي تلتزم بها الكويت مع الدول الأخرى، مثل اتفاقية مهمة وهي حماية الاستثمارات التي دخلت حيز التنفيذ عام 1986. ومن أهم بنود هذه الاتفاقية المادة 4 و6 و8. راح أتكلم عن المادة بشكل سريع أو عن المواد بشكل عام. المادة 4 التعويض عن الضرر أو الخسارة. المستثمرون التابعون لإحدى الدول المتعاقدة الذين تتكبد استثماراتهم في الأراضي والمناطق البحرية للدول المتعاقدة الأخرى خسائر بسبب الحرب أو النزاعات المسلحة الأخرى أو حالات الطوارئ الوطنية أو التمرد أو العصيان أو الشغب في الأراضي والمناطق البحرية التابعة للدولة المتعاقدة. تمنح الدولة المتعاقدة الأخيرة من قبل الدولة المتعاقدة فيما يتعلق بالتدابير التعويضية ذات الصلة المعتمدة معاملة غير مواتية من تلك التي تمنحها الدول المتعاقدة الأخيرة للمستثمرين أي دولة ثالثة. مع عدم الإخلال بالفقرة 1 من هذه المادة، فإن مستثمري دولة متعاقدة واحدة الذين في أي من الأحداث المشار إليها في تلك الفقرة يعانون أو يتعرضون للخسارة في الأراضي والمناطق البحرية للدولة المتعاقدة الأخرى الناتجة طبعا ألف مصادرة ممتلكاتهم من قبل قواتها أو سلطاتها، باء تدمير ممتلكاتهم من قبل قواتها أو سلطاتها على نحو لم يكن بسبب أعمال قتالية أو لم تكن تقتضي ضرورة الوضع. يجب منح تعويض عادل ومعقول وغير تمييزي عن الضرر أو الخسارة المتكبدة خلال فترة الاستيلاء أو نتيجة تدمير الممتلكات. يجب أن تكون المدفوعات الناتجة بعملة قابلة للتحويل وقابلة لإعادة الاستثمار والعوائد. المادة 6 إعادة الاستثمار أو إعادة العوائد اللي نتيجة الاستثمارات. 1 على كل دولة متعاقدة وفقا لقوانينها ولوائحها أن تسمح دون تأخير لا مبرر له بالتحويل بأي عملة قابلة للتحويل. ألف صافي الأرباح وأرباح الأسهم والأتاوات والمساعدة الفنية ورسوم الخدمات الفنية والفوائد والعوائد الأخرى المتأتية من أي استثمار من قبل المستثمر من الدولة المتعاقدة الأخرى. باء العائدات المتأتية من التصفية الكلية أو الجزئية لأي استثمار قام به مستثمر من الدول المتعاقدة الأخرى. جيم الأموال لسداد القروض التي اعترضت كل الدولتين المتعاقدتين باستثماراتهما. دال أرباح مواطني الدولة المتعاقدة الأخرى وموظفيهم الذين يسمح لهم بالعمل فيما يتعلق باستثمار في أراضيها ومناطقها البحرية. دون تقييد، عمومية المادة 5 في هذه الاتفاقية تتعهد الدول المتعاقدة بمنح التحويلات المشار إليها في الفقرة 1 من هذه المادة معاملة مواتية مثل تلك الممنوحة للتحويلات الناشئة عن الاستثمارات التي يقوم بها مستثمر أي دولة ثالثة. 3 لأغراض هذه الاتفاقية يتم تحديد أسعار الصرف وفقا للأسعار الرسمية المتفق عليها مع صندوق النقد الدولي، أو في حالة عدم وجود مثل هذه الأسعار أسعار الصرف الرسمية لحقوق السحب الخاصة أو الدولار الأمريكي أو أي العملات الأخرى القابلة للتحويل المتفق عليها بين الدولتين المتعاقدتين. 4 تخضع عمليات النقل المذكورة أعلى لحق الحكومة المضيفة في فرض قيود معقولة تتجاوز لوائحها الحالية المتعلقة بضوابط النقد الأجنبي لفترات مؤقتة لا تتجاوز 6 أشهر لمواجهة الحالات الأساسية. عدم التوازن الاقتصادي بشرط السماح بإعادة 50% من هذه التحويلات إلى الوطن خلال هذه الفترة. 8 تسوية منازعات الاستثمار. هذه المادة 8 الفقرة 1 يجب تسوية النزاعات أو الخلافات بين دولة متعاقدة ومستثمر من الدولة المتعاقدة الأخرى بشأن استثمار ذلك المستثمر في أراضي الدولة المتعاقدة السابقة ومناطقها البحرية والدين إن أمكن. اثنين، إذا تعذر تسوية مثل هذه النزاعات أو نزاعات وفقا لأحكام الفقرة 1 من هذه المادة في غضون 6 أشهر من تاريخ طلب أي من الطرفين التسوية الودية، ولم يتفق الطرفان على أي إجراءات تسوية أخرى للنزاع، يجوز للمستثمر المعني أن يختار إحدى وسيلتي الحل التاليتين أو كليهما. ألف، تقديم شكوى إلى السلطة الإدارية المختصة أو الوكالة المختصة في الدولة المتعاقدة التي تم الاستثمار في أراضيها أو مناطقها البحرية وطلب الإغاثة منهم. رفع الدعوة أمام المحكمة المختصة في الدولة المتعاقدة التي تم الاستثمار في أراضيها أو مناطقها البحرية. 3، يمكن تقديم النزاع المتعلق بمبلغ التعويض وأي نزاع آخر يتفق عليه الطرفان إلى هيئة التحكيم. تتشكل هيئة التحكيم الدولية المذكورة عليها بشكل خاص بالطريقة التالية: يقوم كل طرف في النزاع بتعيين محكم، يقوم المحكمان بتعيين محكم كرئيس يكون من مواطني دولة ثالثة لها علاقة دبلوماسية مع كلتا الدولتين المتعاقدتين. يتم تعيين المحكمين خلال شهرين، والرئيس خلال 4 أشهر من تاريخ اختار الطرف الآخر بإحالة النزاع إلى التحكيم. إذا لم يتم إجراء التعيينات اللازمة خلال الفترة المحددة في الفقرة السابقة، فيجوز لأي من الطرفين في حالة عدم وجود أي اتفاق آخر أن يطلب من رئيس معهد التحكيم الدولي التابع لغرفة التجارة بستوكهولم إجراء التعيينات اللازمة. تحدد هيئة التحكيم إجراءات التحكيم الخاصة بها من خلال الإحالة. أما إلى اتفاقية تسوية منازعة الاستثمار بين الدول ومواطني الدولة الأخرى المبرمة في واشنطن 18 مارس 1965، أو إلى تحكيم لجنة الأمم المتحدة لقانون التجارة الدولية الانستثمار، يجب أن تصل هيئة التحكيم إلى حكمها بناء على أحكام هذه الاتفاقية والقوانين المحلية ذات الصلة والاتفاقيات التي أبرمتها الدولتان المتعاقدتان ومبادئ القانون الدولي المعترف بها. عموما، تجتمع هيئة التحكيم في دولة ثالثة يتم اختيارها باتفاق مشترك من قبل الأطراف المعنية في ستوكهولم، أو إذا لم يتم الاختيار في غضون 45 يوم من تعيين العضو النهائي، يجب أن تصل المحكمة إلى قراراتها بالأغلبية من الأصوات. يجب أن يكون الحكم نهائي وملزم للطرفين. عندما تصل المحكمة يجب أن تحدد أساسها القانون، بناء على طلب أي من الطرفين يجب تفسيره. يتحمل كل طرف تكاليف المحكم الذي عين ونفقاته الخاصة أثناء إجراء التحكيم. يتحمل كل الطرفين نفقات رئيس المحكمة وتكاليف الأخرى بالتساوي. 4، بالإضافة إلى الأحكام السابقة لهذه المادة، يجوز تسوية المنازعات بين مستثمري دولة متعاقدة ومستثمري الدولة المتعاقدة الأخرى التي تم الاستثمار في أراضيها أو مناطقها البحرية عن طريق التحكيم الدولي وفقا لشروط التحكيم بين الطرفين. يجوز لأي من الدولتين المتعاقدتين متابعة أي مسألة محالة إلى التحكيم عبر القنوات الدبلوماسية حتى تنتهي الإجراءات. وفشلت دولة متعاقدة في الالتزام أو الامتثال لقرار التحكيم الصادر عن هيئة التحكيم. أما الاتفاقية الخاصة لتجنب الازدواج الضريبي ومنع التهرب المالي فيما يتعلق بالضرائب على الدخل ورأس المال، كما تنص المادة من هذه الاتفاقية، تطبق على الأشخاص المقيمين في إحدى الدول. ومن أهم بنود هذه الاتفاقية المادة 14 21 22 24. الاتفاقيات المادة 14 الخدمات الشخصية، والمادة 21 هي الطلاب والمتدربون، المادة 22 الدخل الآخر، الغاء الازدواج الخارجي. راح أتكلم بشكل سريع عن المادة 14. قطاع الدخل الذي يكتسبه مقيم في دولة متعاقدة فيما يتعلق بخدمات مهنية أو أنشطة أخرى ذات، إذا كان المقيم مركز ثابت متاح له بصفة منتظمة في الدول المتعاقدة الأخرى لغرض أداء أنشطته، ففي تلك الحالة يجوز للدولة المتعاقدة الأخرى الفرض ضريبة على ذلك الجزء من الدخل الذي ينسب إلى المركز الثابت. المادة تشمل عبارة المادة بوجه خاص الأنشطة المستقلة في المجالات العلمية والإدارية والفنية أو التعليمية أو التربوية، وكذلك الأنشطة المستقلة التي يزاولها الأطباء والمحامون والمهندسون وأطباء الأسنان والمحاصيل. مادة 21 الطلاب والمتدربون. الطلاب أو المتدرب الذي يكون أو كان قبيل زيارته لدولة متعاقدة مقيم في دولة المتعاقدة الأخرى ومتواجد في الدولة المذكورة أولا فقط لفرض التعليم أو التدريب يعفى من الضريبة. ألف المدفوعات التي يحصل عليها من مصادر خارج الدولة المتعاقدة المذكورة أولا لفرض ضريبة منح أو المنح الدراسية كذلك شاملة معفية من الضريبة. المادة 22 الدخل الآخر. بنود لا تنطبق أحكام الفقرة الواحد على الدخل الآخر. المادة 24 إلغاء الازدواج الضريبي. بالكويت إذا امتلك مقيم في الكويت دخل أو وأرسل هذا الدخل للصين يجوز للكويت أن تفرض الضريبة على تلك البنود من الدخل ورأس المال. في الصين إذا اكتسب مقيم في الصين دخلا من الكويت يجوز خصم قيمة الضريبة مستحق الدفع الكويت والمحسوبة على الدخل بموجب أحكام هذه الاتفاقية. ويعطيكم العافية وتقريبا خلص.
مشكور استاذ خالد، يعطيك الف عافيه. طبعا يعني حاولوا يدشون علينا يهجمون علينا مجموعه من الهاكرز من باكستان، بس هالمره صرت ذكيه ومثل المره اللي طافت جبت 2 هاكرز واحد معاه يفني وواحد بمكانه، فما قدروا طبعا يسوون شيء، دخلوا على الكويستشن وقاموا يسبون. فالحمد لله يعني عدت. يعطيكم الف عافيه الصراحه، يعني كان كلكم presentation مالكم وايد حلو. Just I'm sorry for Sarah, lawyer Sarah, she have a problem. عندها مشكلة بالسيرفيس مع الأسف. تكلمت شوية وما قدرت، فطرشت لي إيميل تتشكر وتتأسف منكم. يعطيكم ألف عافية. مشكورين وايد.
يعطيك العافية. مشكورة أنت وجهود والله تشكرين عليها وبرافو عليك. أنا أحييك على اللي أنت تعرضتي عليه. إحنا قاعد نشوف الهجمات، الأصوات ما قاعد تطلع، يحاولون يخربون مؤتمرك، بس أنت قدها وأنت قوية وأنا فخورة فيك والله. وأفرح لك والله، وبالعكس مؤتمرك ناجح وبصراحة أنت كنت يونيك في هذا الاختيار.
مشكورة بعد عمري. ثانك يو. مشكورة تسلمين ما قصرتي.
حبيبة قلبي.
ثانك يو فور مشكورة بدور ومشكور استاذ خالد ومشكوره ساره الرشيدي على ادارتك المتميزه. ثانك يو فور ذا لايرز، هم موجودين بس مسكرين الفيديوهات. ثانك يو فور اليسيا and Queen and Professor Shai. Thank you very much. Thank you also for Wang. Thank you for your time. يعني خصوصا ان هم كلكم طبعا كل المتحدثين معنا بشكل تطوعي يعني. ثانك يو فيري ماتش. دكتوره سلوى حياك الله مره ثانيه معنا.
الله يسلمك. اذا تسمحي لي بس بكلمه، اذا ممكن ما اخذ وقتكم، عسى مش طويل. بسم الله الرحمن الرحيم. طبعا شكرا، كل الشكر والتقدير لك استاذه اريج على دعوتك، وبالعكس انا اعتبر يمكن من كثر ما شاء الله مع ازمه كورونا بالاسبوع لا يقل عن 3 مشاركات لي، اما متحدث او مستمع او يعني ادير لقاءات. للامانه يمكن قليل جدا من قام بعمل بجهود فرديه تطوعيه من قبلك بتنظيم مثل هذا الايفنت، وخاصه مع تشاينا. يعني اليوم الكل يعرف ان تشاينا يعني شيز ون اوف ذا ليد كونتري في عالم البزنس، ولا شك ان يعني طبعا حكومه دوله الكويت دائما تسعى من خلال مبادراتها المختلفه في قضيه التوسع في البزنس مع تشاينا. اليوم المواضيع اللي طرحوها الساده المشاركين مهمه جدا. يمكن انا شخصيا بعض الاشياء اللي اول مره اعرفها، ايضا بعض الاطروحات اللي قدمت في قضيه المشاريع الصغيره والقوانين وما الى ذلك. يمكن انا اشير الى اشياء مثلا سريعه جدا، يعني حتى تكون مثل برامج عمل او توصيات مستقبليه. يعني يمكن من خلال خلينا نقول مشاركتي في العديد من مناقشات الاكاديميه اليوم، بس يمكن حتى انا راح اقولها بالعربي، يمكن حتى راح اقولها بالانجليزي. اليوم مساله ان احنا نعمل اللي هو تبادل البزنس مع تشاينا مهم جدا. اليوم دور السفارات وهذه مهمه جدا، لان انا قاعده اطالع موضوع مثلا اعتماد الاوراق اللي هو الاكريديشن، قاعد انا داخل مثلا في مناقصه، في تاهيل، في اي امور، قاعد هذه شويه تحتاج من يعني الناس اللي في تشاينا انهم يعني يسهلون مثل هذه الاجراءات. اليوم ايضا تكلموا على عمليه الضمانات، يعني الضمانات، لان اليوم لما نفتح بزنس شراكه ما بين الكويت وتشاينا مهم جدا ان احنا يعني المستثمر خلينا نقول اللي تو بادئ الكويتي لو بروح مثلا يعمل بزنس في تشاينا، ايضا احنا ودنا نعرف انه هو في سكيور يتعامل مع منو، مع نوعيه المكاتب المحاماه ليكون يستقل او مثلا غير ملم، ومو الكثير طبعا تعرفون لغه تشاينا ما هي اللغه العامه مثل الانجليزي، فهذه تحتاج الى ان احنا يعني ايضا نرتبها. لكن بشكل عام بالعكس انا اهنيك واشكرك. طبعا الهاكرز ما يخلونا بكل مكان، يعني حتى الاسبوع اللي فات كان عندنا هاكرز دخل على منتدى كبير حق برنامج التعاون، ايضا كان على الاحتكار ورياده الاعمال. بس بالنهايه يعني رساله وصلت، جهود مشكوره. شكرا لاداره الجلسه. ساره كنتي بالعكس ما شاء الله عليك، يعني عندك حسن التدبر السريع. هذا الحين اللقاءات عن بعد تبي لها شويه تدخل سريع جدا يعني ما تبي لها شويه توهق وكل حاجه، ولا من الميكروفونات ساعات يوهق ناس وايد، يعني على بالها مسكرته وتنساه. على العموم كل التوفيق اختي اريج، وبالعكس نعين ونعاون. Thank you so much our partner from China. We like your speeches. I think today you make a valuable knowledge for all the investors for coming future between state of Kuwait and China. Thank you again. Listen to you and good luck to everybody.
دكتورة سلوى على كلمتك الجميلة، والحمد لله ان هالنوع من المؤتمرات فعلا احنا محتاجينها. لازم نكون ابديت على القوانين الجديدة اللي قاعدة تتم. تعودنا دائما ان الاجانب يعني مهتمين فيما يحصل باسواقنا، بس ما قاعدين احنا مو مهتمين ان ندش اسواقهم، واعتقد هذا غلط. يعني لازم نبتدي نتطور في هذا المجال، وحتى عشان كذي انا حبيت اسوي من صوبي حسب اختصاصي الدراسه القانونيه اللي اليوم حصلت وسمعناهم. يعطيكم الف عافيه. اذا في احد عنده سؤال؟ ما في؟ انا اللي معاي خلاص تعب لان شغالين. Professor Shai, thank you very much again. If you have more things you want to talk about, because we didn't. لحظة, wait a minute, please. شلون أسوي wait. Okay. Yes, Professor Shai, if you want to continue your speech, it's okay.
It's okay. Since I already sent you my draft of the presentation, I think I will see the words here. Thank you. It's my great pleasure attending this webinar. Congratulations for this successful event. Thank you for your invitation and good luck for everyone. Thank you.
Very much. Thank you for your time. And I'm sorry because there is some hackers, they try to damage our webinar. But it's good that I bring IT team. Thank you. Thank you, Elisa, again.
You're welcome, and thank you very much for inviting.
Thank you so much. Thank you, Mr. Quine, again. Thank you so much for your presentation. Thank you for your time.
Thank you, Harry. Do you have any question?
I don't know if they have any question, but for me, I would like to ask all of you, if I want to start my company in China with this law, what is the procedure and how can I start? And what is the amount? There is there is a limit for the amount of the company. شنو راس مال نسيت؟ ها؟ Capital.
With the budget, with her budget.
So the video is disabled, right? Is the video disabled? Can you hear me?
Yeah, we hear you.
There is no video, only your face, your video.
Okay. Okay. According to new law, yes, I think Mr. Wang has mentioned this time frame for setup of new FIE. It's about probably 4 weeks. That's enough, maybe. If it's in the negative list, or if otherwise you just need to report, make a record filing with the related MOFCOM branches.
Yeah.
And there is no, according to new law, the company law will be applied to foreign investment enterprise. That means, according to company law, the registered capital is whatever you want. If you want to put in 3 years later or 10 years later, it's okay. Just no money required. But formally, traditionally,
يتم إيداعه لاحقا خلال سنة إلى 3 سنوات. و رأس المال
in advance, and you must meet the ratio requirement for the registered capital with the total investment volume. So that's different. So under the FIE law, there's no requirement for capital, registered capital. It's just acknowledgement of investment in later, anytime you want. And then you can put in an article of association. That's enough.
What's the minimum capital if we want to encourage the youth investors? So what's the minimum capital?
What kind of sector?
I mean, if there is a youth Kuwaitis who want to invest in China and they don't have a big budget, so what's the minimum capital or what's the minimum budget?
No capital registered capital is needed at this time. But for some special regulations on different industries like financial institutions and also like oil and gas. The oil and gas minimum requirement for capital is 300 million RMB. That's the minimum requirement. But for generally other general index sectors, there's no minimum capital requirement. That's the new law.
Thank you very much, Mr. Queen. Okay, there is somebody, they have the questions, but I'm afraid to open for them the video because there is many of hackers, they try to damage. So I write for them. Anybody they have question, please write your question in the chatting and we will...
Yeah, I have a question, please.
Okay.
Okay, including this conference, you pointed to several key macro financial risks next to geopolitical risks that may trigger a stronger slowdown or even a hard landing of the Chinese economy if they are not managed well. My question, in your view, what are the most important macro financial risks that could derail the base scenario of the gradual investment? Second question, how might the trade war and the worldwide pandemic affect on the investment? Thank you, appreciate.
Thank you very much. I think she's Arij here. Okay. Yeah, Professor Shai, can you answer for her question, please?
I don't see any specific financial risks for investing in China right now. I think first step you need to, you cannot invest in industry, on the negative list, which particularly, for prohibition of foreign investment into China. That's not allowed foreign investment. For restricted category, you need to, your investment is subject to the restriction. The COVID-19 pandemic has a big impact on Chinese economy as well. But as you can see, Chinese GDP is still, for this year, the increase is reduced, but still it has been increasing slowly and gradually recovering. That's why I said, I cannot see, any specific financial risks investing in China right now. But still, I think it depends on the sector you are investing. I don't quite get your second question. Can you say it again? The second question, what did you ask?
Second question, how might the trade war and the worldwide pandemic affect on the investment? This is the second. And the first question, it was, in your view, what are the most important macro financial risks that could derail the base scenario of the gradual investment?
Also, your second question concerned COVID-19 pandemic. I think I already addressed, even the pandemic has a big impact on Chinese economy, but I don't think, as you can see from the statistics, Chinese economy still has been gradually increasing. And compared to other countries, major developed economies and large developing economies, Chinese economy right now, the performance of Chinese economy is still one of the best. So, only depending on the sector you are investing, you need to do more investigation. But generally speaking, I don't see any specific financial risks investing in China.
Great. Appreciate for your answer.
Thank you.
Thank you very much, Professor Shai. We have for Lisa, please, if you can listening. There is 2 questions in the question page. They ask what the investment in education now by this law. And there is other question about Alibaba, if the Kuwaiti person can register by the payment. I don't know, this is what the question. So please, if you can answer this.
Yes, regarding the first question, what's the new law about education now? First of all, we need to specify what kind of education we are talking about, because if it's the mandatory education, means that from primary school and middle school, that's totally prohibited from foreign investment. Also, any education related to religion is also prohibited from foreign investment. However, if it's the preschool education, meaning kindergarten, or if it's high school, or education institution or institution of superior education. In this area, it is allowed, foreign investment is allowed. However, it's restricted in the way that the Chinese party must be the leading party, meaning the school principal or the major administrative responsible person shall have the Chinese nationality. Also, the board of director or joint management committee shall have the Chinese members of more than half of the members, meaning the Chinese party will be leading, will be taking the dominance of the committee. So on a third level, in the free trade zone right now, it is allowed for wholly foreign-owned company to invest in professional education institution. So in summary, to answer this question, we need to divide or specify what kind of education it is. And then regarding the different kind of education, or there is the green light in a free trade zone, but only for professional education institution. I'm not sure if I explain myself well.
أريج طالع عندك أسئلة بعد؟ لأن أنا آخر سؤال طالع من أستاذ بدور.
Thank you very much, Lisa. There is the other question مكتوب بالعربي about Alibaba.
Sorry, which is the second question because I didn't get.
You didn't get? Okay. تقرينا سارة؟
أنا بصراحة حتى بالعربي ماني فاهمة شنو يبي من هالسؤال.
They ask about Alibaba company. If the Kuwaiti person can register in the company, technology company, or just now I know as I read in this law that any person now or investment out of China, they can start their company 100%. And this is what all they said. So the question they ask, if there is a Kuwaiti investors, they want to be a partner in Alibaba company. How it will be? Is it okay or no? I don't know if you understand. This is what I understand with these questions.
Okay, I got your question. Well, regarding this, we need to check on the negative list to see if the part of the business owned by Alibaba that the Kuwait partner wants to join is on the negative list or not, because we know that Alibaba is a big group, and under the group there are different subsidiaries working in different sectors. There is finance, there is e-commerce, there is technology. So it's hard to just mention Alibaba, but need to specify which kind of business, which kind of operation that the foreign investment wants to join. And then once it's specified, it's decided, we can check on the negative list to see if it's totally prohibited or if it's restricted. Restriction normally meaning foreign investment is allowed, but cannot exceed 50%. So to answer this question, first, we need to narrow down the scope to understand which kind of business the foreign investment wants to target, and then we check the negative list. Basically, that's the procedure. I hope my answer can help a bit with the question.
Thank you very much. Thank you very much. Just regarding the education question, they said that they mean the training teachers. What about this kind of business?
Training teacher.
Yeah.
You mean it's like providing professional training for teachers, like regarding the education?
Right. I mean, of education is training teachers and the new selfless. So, selfless. Not
so,
yeah.
You mean it's a kind of online education or setting up a physical school, training Chinese teachers or training, you know, the question seems to me is not that clear.
If they want to open, for example, a school or something in company out of China, they should use a Chinese teacher, or they can use other teachers from out of China. I will ask him now that.
Sorry, was that question directed to me?
To Professor Chai, please. Or for you, it's equal, yeah, no problem. Maybe she didn't listen. I think she stopped her picture. So can you, Elisa, please answer this question for them?
I just want to make sure I heard the question right. You were asking, is it allowed to use foreign teachers in the school?
Yeah.
Or, is that the question?
He's asking about the training, the training for teachers.
Teacher.
Maybe he meant that he meant that we need your experience by giving a training for the teachers.
Okay. I think it will involve what kind of training, but if you said if general training on teaching method or teaching skills, for now I don't think it's prohibited or restricted. But of course, we need to more details to have a more comprehensive assessment. And also, I think depending on where this school or where this training is provided, maybe local government or local laws regulation would have something to say about it. So at this time, it's really hard to say whether it's like green light or red light, or whether it has any kind of restriction. So I think also, as what I mentioned in my speech, it's very important to contact the local legal assistance to have a more comprehensive assessment with all the details and information of this potential investment in order to evaluate whether it's a feasible project and where will be the best destination for this investment project. Thank you.
Thank you very much. Thank you. I would like to open for them, but they have many questions, but really I'm afraid from the hackers. So please, I'm so sorry. There is many questions they would like to ask. Now, Mr. Abdullah, he asked about the Alibaba, that if they can, I think, because they write a small question, so it's not very clear. He said if they can, the technology payment, like, Visa, MasterCard, if they want to open like this cards in payment, technology payment as an investment, is it okay? I think this is his question.
So I think
سؤال صغير، ما انت قاعد تشوفين صفحة الأسئلة.
Yes. He corrected it. He said the Alipay, not the Alibaba.
So Alibaba.
I think it's
Alibaba. Okay, he asked about Alipay, not Alibaba. Alipay. Did you hear me, Elisa? Okay, who can answer this question?
You need to specify what kind of specific question relating to Alipay.
Sorry, Professor Shai, can you repeat again, please? What you said?
I guess you need to specify what kind of question, what kind of specific question relating to Alipay. It's the investor wants to use the payment platform, or what exactly?
He wants to open account for payments in Alipay. He said if it's a bit approval, if he could sign up or open the account in Alipay.
I don't have experience with Alipay, but I do, you know, I use like WeChat payment every day. So basically you need to have a banking account connected to you know, your accounts to Alipay as well. But for WeChat payment, the first step is that you need to open a.
I didn't fully understand your question, but I think if you want to open an Alipay account as a foreigner, then that's a different thing. That's not a thing it's not a question of a foreign investment. I think that's just different matter.
It depends. Investment and indirect investment. So if he or she can open a account with Alipay and he puts a lot of money into that account, it's very hard to say it's not a foreign investment or not. Because
if a foreigner wants to open an account in another country, if you don't have a official stay, a visa, and enough time of stay there, maybe it's not enough. It's not allowed to open an account. But I'm not sure because I'm not working on financial stuff in this. So most of our measure is about transport investment, especially in the mineral resource, mining, energy, and like that. So this question is beyond my capability, but I think it's not a question of a foreign investment. It's just kind of a financial regulations. We had to consult with the Alipay to make sure the foreigner what's the requirement for opening up of account. So that's what.
Well, I think opening a Chinese banking account is the first step. That's generally required. You need to have you need to confirm with some condition to open a banking account with Chinese bank. I think that's what generally required.
Okay.